It's finished. The Supreme Court just dropped a 6-3 earthquake that erased a major gun rule in America. The kicker? The regulation they vaporized was Donald Trump's own. That's correct, a right-leaning court, including 3 Trump picks, just torched the flagship fix Trump demanded after the worst solo mass shooting in modern history. Here's what the networks aren't saying. This isn't merely about firearms. It redraws how Washington can police any brand new tech. Fallout is landing live. Hit subscribe, because Second Amendment court wars are detonating nationwide, and you'll need updates fast. The jaw-dropping vote, the 6-3 divide that revealed the trigger loophole, is rewriting the playbook. On 14th June 2024, the court issued Garland versus Cargill, and Bedlam followed. Yet, here's the hidden story. The ruling nuked a ban that President Trump personally ordered after the nation's bloodiest solo massacre. First, October 2017, Route 91, Harvest Festival, Las Vegas, 22,000 fans at a country show. At 10:05 p.m., gunshots pour from the 32nd floor Mandalay Bay suite for 10 straight minutes. More than 1,000 rounds spray the crowd. When the echo stops, 58 are dead, and over 500 bare bullet wounds, the deadliest lone gunman slaughter in U.S. history. Police recover 14 rifles wearing bump stocks, plastic add-ons that crank firing speed to near automatic. Even the NRA said the gadgets should face new limits. Trump told ATF to outlaw them now. In 2018, the agency relabeled bump stocks as machine guns, erasing legal ownership. Justice Clarence Thomas penned the majority that killed that rule, joined by Roberts, Alito, Gorsuch, Kavanaugh, and Barrett, 3 of them Trump appointees. The sting. Thomas, long viewed as a rock by gun owners, just issued an opinion so mechanically narrow that it ties the hands of every future regulator chasing new firearm tech. Within 2 days, makers declared production restarts. ATF once figured 520,000 bump stocks were in circulation pre-ban. Now, millions more may flood the market. Thomas, long viewed as a rock by gun owners, just issued an opinion so mechanically narrow that it ties the hands of every future regulator chasing new firearm tech. Within 2 days, makers declared production restarts. ATF once figured 520,000 bump stocks were in circulation pre-ban. Now, millions more may flood the market. The legal snare Thomas built goes beyond one gadget. Lawyers call it the 1934 trap. The National Firearms Act of 1934 says a machine gun fires automatically more than one shot by a single function of the trigger. Thomas zeroed in on single function. Cable panels missed this. By reading that 90-year-old phrase with microscope literalism, he handed the gun industry a blueprint to outdesign any future rule. The line that shatters the status quo. A bump stock never makes the rifle truly automatic. Instead, it harnesses recoil so the gun bounces off your rigid finger while the trigger resets between shots. Thomas declared those rapid multiple presses are many functions, not one. The terrifying part, demanding word-for-word obedience to 1934 text means agencies can't touch new gun tech unless Congress pens a new statute every single time, and Congress is frozen on guns. So, what is a bump stock? It re-engineers how fast a semi-auto rifle cycles. You squeeze once, the rifle fires, recoils rearward, then the stock lets the whole gun slide forward again while your finger stays put. Recoil repeats the dance. Outcome: 400, 800 rounds a minute, matching Army issue rates. 1st October 2017, Stephen Paddock, 32nd floor, Mandalay Bay, opens up on 22,000 concertgoers for 10 minutes. Automatic sounding bursts rake Las Vegas. 58 killed, 546 struck by bullets, hundreds more hurt fleeing. SWAT finds 24 guns, 14 wearing bump stocks, over 1,000 brass cases. The stocks were key to the body count. Trump ordered ATF action. December 2018, the agency reclassifies the devices as machine guns. Owners got 90 days to destroy them. Michael Cargill, a Texas gun store owner, turned in 2 units, then sued. He, the 14th June 2024. 6 justices sided with him. Whether Thomas meant to or not, he just handed makers a how-to guide for end-running federal law. The regulatory collapse. The court didn't merely re-legalize one accessory, it crippled ATF's power to police anything invented after Congress last updated gun statutes. Within 72 hours, 6 firms announced restart plans. Web searches for bump stock spiked 4,700%, and this is only the warm-up. Binary triggers spit 1 round on pull, 1 on release. Under Thomas logic, they flunk the 1934 wording. Forced reset triggers use the bolt to shove the trigger forward faster than humanly possible. Cargill, yielding near-automatic rates. ATF mailed cease and desist letters in 2021 to 22. Post-Cargill, that enforcement theory is rubble. Some states are already rushing tech fixes that should worry every owner. California lawmakers have floated digital CCW permit systems, building compliance databases. ATF already runs the National Tracing Center, holding records on millions of firearms. The tracking backbone exists. Cargill just blocked the feds from policing what owners do with those guns. Congress hasn't touched the machine gun definition since 1986. 38 years of innovation without statutory edits. ATF can't regulate. Courts will swat rules down. Congress won't move because it's paralyzed. Experts whisper we're entering an age when federal firearms law simply can't keep up with invention. The agency power angle the press keeps missing. Cargill isn't really about stocks. It's about whether any agency can attack modern problems with statutes drafted before those problems existed. 2 weeks after Cargill, the court dropped Loper Bright Enterprises vs. Raimondo on 28th of June 2024, overturning Chevron deference, 40-year-old settled law. Same 6 votes, same lineup. Coincidence? Nope. It's a coordinated campaign to dismantle administrative state power. The precedent doesn't stop at guns. If agencies can't reinterpret 90-year-old phrases for new tech, goodbye environmental rules, food safety regs, drug approvals, every field where Congress wrote broad language expecting experts to fill gaps. Cargill just rewired how the entire bureaucracy operates. EPA policing new pollutants, hogtied, FDA reviewing novel therapies, shackled, FCC tackling emerging tech, hamstrung, ATF keeping gun law current, paralyzed. The Bureau has about 5,000 staff. Congress last updated gun law in 1986. Since then, 3D printed guns, ghost guns, pistol braces, forced reset triggers, binary triggers. ATF used flexible regs to chase those trends. Cargill slammed the door. A Yale professor summed it up. The court now forces Congress to make product-by-product calls on tech that didn't exist when the statutes were written. Legislators move slowly. Technology sprints. Agencies exist to bridge that gap. This court says the gap must stay open unless Congress acts. Congress is gridlocked, so the gap stays wide. In the 6 months since Cargill, ATF has yanked or delayed at least 4 proposed rules because litigators will kill them under the new precedent. Second Amendment aftershock. 2 years before Cargill, June 2022, the court decided NY State Rifle and Pistol Assen v. Bruin, scrapping New York's carry licensing scheme and announcing a new test. Gun rules must fit historical tradition from the founding era. Cargill applies that yardstick with surgical exactness. If a 1934 statute uses precise mechanical language, courts must stick to those words even when modern devices achieve the identical result. That logic is rippling through district courts. Illinois, California, New York, and Maryland assault weapon bans are under attack, citing Cargill. ATF's ghost gun rule demanding serial numbers is being sued. Pistol brace rules covering millions of AR-style pistons already face multiple injunctions. Scale check. An estimated 10-40 million AR platform rifles sit in private hands, all except bump stocks, binary triggers, forced reset triggers, endless add-ons. Americans bought 16.6 million firearms in 2023 alone. The entire federal framework governing those weapons just got dynamited. Justice Sotomayor's dissent. When I see a bird that walks like a duck, swims like a duck, and quacks like a duck, I call that bird a duck. A bump, stock-equipped semi-automatic rifle fires automatically more than one shot without manual reloading by a single function of the trigger. I would follow Congress and call that a machine gun. I respectfully dissent. Gun rights groups hailed Cargill as a win for constitutional limits. Gun safety outfits denounced it as reckless. Both camps agree the rulebook just got rewritten. Bottom line, the court told agencies they cannot ban firearm accessories without explicit congressional authority, and Congress isn't about to pass new gun statutes. Bump stocks are legal again, binary triggers float in limbo, and manufacturers are already drafting new gadgets exploiting Thomas's trigger loophole. Whether you view Cargill as restoring constitutional boundaries or opening a deadly gap, one truth is undeniable. The federal architecture policing firearms just collapsed. So here's my question. Should the ATF have power to ban new firearm technology through regulation, or must Congress pass a specific law for every single device? Drop your answer in the comments.